Hey there, welcome everybody. State planning attorney Paul Rabelais here again, and here to talk to you about. Let me get some things straight on my screen. I can't see what I'm doing. All right, so here today to talk to you about your life support machines decision. So it's the life support machines decision. It's sometimes kind of an afterthought as part of the overall putting your estate legal affairs in order. Because when you do put your estate legal affairs in order, there's all these decisions: who's going to be your heirs, who's going to be your executor, your trustee of your trust if you have a trust, uh, financial power of attorney. How do you leave things to your spouse, to your kids? Do you leave it outright? Do you make it divorce proof? There's so many decisions involved with creating your estate plan and keeping it up to date that sometimes this, oh, by the way, let's quickie do the quickie living will, because that's part of it as well. And really, probably more thought needs to go into people's living will decisions than really occurs, because there's so many other aspects of funding your trust and transferring your home and all the tax consequences of everything and beneficiary designation. So anyway, we'll look this evening about can talk about why this decision is so important. We'll talk about the decisions that you make when you are creating or updating your estate plan as it relates to the withholding or withdrawal of life sustaining procedures. We'll talk about some of the common issues and common questions that are out there. If you do have some questions, feel free to throw them in the chat and we'll get to them after the presentation. So some of the history behind this whole life support machines decision is there was a court case back in the late 90s and early 2000s. Some of you may remember it. It was national news. There was a woman named Terry Chavo. She was on life support. Her husband, I believe, wanted to remove the life support systems. Her parents wanted to keep the life support systems in place, holding out hope. And there was a 7-year-long battle. I believe the Florida governor, the president got involved, and it was just a terrible situation for everybody. She ended up passing away in 2005 after the life support machines were withheld. So that spawned all of these states to create some type of living will law. And I will tell you, over the years, I've been doing this for 30 something years now. I have had a lot of people, talk to me and say, Paul, when my mother was sick, she was at the end stages, and yeah, she had signed a living will, and you know what, it made it easier for us kids. So it's good to hear those stories when parents take care of these things, and it does relieve a burden that the children may otherwise have. Because really what we're talking about here, bluntly speaking, is we're talking about removing life support machines, life sustaining procedures, when someone is at that end of life stage. We'll be talking about that here this evening, talking about some of the decisions that people make when they create or implement their living will. So the bottom line on the whole living will thing is that the patient that's in the hospital or wherever they are, you have a right to make your own healthcare decisions. And states enacting all of this living will or declaration legislation, they're putting laws into place that allow patients ahead of time to make their kind of end of life decisions about treatment. And so living will laws were passed, making these living wills valid and binding. So the legislation says, you, while you're capable, have the ability to make your end of life decisions. And so the way a lot of people look at it when they create their living will, they're like, I don't want to burden my family with having to make that end of life decision. I want to have a living will in place. I want to keep them from being forced to make that difficult decision. I want to make it easy for them. So that's what a lot of parents say when they create or implement their living will. All right, so just some lingo real quick. Know that I keep using. I've already used the term living will a number of times in this live stream. So living will means something entirely different than will or last will. So you got to realize, some people say, I wrote my living will 5 years ago, and I left my car to my grandson. So that just doesn't make any sense. So know that there's a difference when we talk about someone creating a living will versus someone creating a last will and testament. So that will of yours or last will and testament, call it any of those things that you want. That's the who gets your stuff when you die and who's going to be the executor to guide the family through that process. So that last will from a meaning perspective is very different from a living will. A living will is where you state your decisions regarding life support machines ahead of time. Again, it's called a living will. It's not a last will and it's not a living trust. So sometimes people say, yeah, I created a living will and I put my house into it. Well, that's it's just lingo and all that, but I laugh when I hear that stuff. So yeah, you may have created a living trust and put your house into it. You may have created a last will and named your heirs and your executor. And then you may have also created a living will, which is not a living trust and it's not a last will, it's a living will, which states your decision regarding life support machines. So a lot of lingo there. And also know there's a distinction on the medical side, often in most states, between a living will and what I'll call a healthcare power of attorney. So we people often kind of misinterpret what I say when in my mind I'm thinking healthcare power of attorney when I ask Fred Flintstone, hey Fred, if you're perhaps in a surgery or somebody needs to go get your medical records, or maybe you have dementia and doctors need to talk to people about your treatment decisions, who do you want to be able to do that? And then Fred may respond, oh, you mean pull the plug? And I'm like, no, that's not what I mean. I'm really talking about all of the medical decisions on your behalf besides the pull the plug. And I know that's kind of the slang term for it, but everybody gets that. So there's often a distinction of a living will, which is your statement and your decision and your directive of your decision about if and when you'd want life sustaining procedures withheld if you're in that profound vegetative state, no chance of recovery. There's a difference between that and the some states call it healthcare power of attorney, advanced healthcare directive, healthcare proxy, where you actually designate people to make medical decisions for you when you just can't make them for yourself. So oftentimes in the living will or the pull the plug type statement, you're not appointing people to make decisions for you. You're making the decision and directing that they honor your wishes. Okay, so let's talk a little bit about lingo. And I spent a little time today reviewing the various states. Every state has its own legislation. Some states call their living will their statement about life support machines. Some people call it a declaration. Some states formally call it a living will. Some states call it a living will directive. Some states call it a healthcare living will. I saw one or two states call it an instruction directive. Noticed a couple of states out there call it an advanced directive for end of life decisions. So there's a whole bunch of terms for it, but essentially what it is, it's where you're saying, if I get to a point during my lifetime where I'm in that profound comatose state, or that you'll see language like terminal and irreversible condition, probably see something like when doctors, or maybe you'll see something in there like when two physicians, one of whom perhaps is my attending physician, certify in writing that I'm in that profound vegetative state, there is no reasonable chance of recovery, then I direct such and such. And maybe the such and such is I direct that life sustaining procedures be withheld and I be permitted to die naturally with enough medication to provide me with comfort care. Maybe you'll see something like that. So let's talk about that for a minute. Know that the standard for a living will to be triggered, you got to be out of it. I think there's some people out there who are like, I'm not signing a living will because I'm afraid that I'm going to be in the hospital and maybe I have a bad headache, and there's this guy with his hands on the plug just ready to just yank it out of the wall. I don't want that to happen too quickly. But know that the living will doesn't even take any into effect under usual circumstances unless you're in that profound comatose state, profound vegetative state, no chance of recovery. Doctors have determined that terminal and irreversible condition. So every state has their terms on when that living will takes effect. And practically speaking, you got to be gone. All right. Now I've seen some state living wills say, I direct that my family and my physicians honor my wishes as I expressed. And when that's the case, I know the way the law applies is no matter what anybody says, when if you have a living will and you direct that your family and your physicians honor it and you've put some terms in it, then they got to follow it. You had the right to make your decision, you made it. Although sometimes you'll see in living wills, it might be expressed something like, these are my wishes. However, I direct that the decision of blank, and maybe there's a name, maybe a spouse or a child. This is what I want to happen, but I direct that the decision of blank be honored. So you can have that state your wishes, but have that family member or person that you really trust to make the decision. You can give someone like that the authority to have the real final say so. In most living wills, not at all, but in a lot of them, because I've looked at virtually all of them from the various states, many of them have some decisions you can kind of check off or initial when there are circumstances in a living will or provisions in a living will where you can initial or check off certain things. The most common things that I see you being permitted to maybe check off in a living will as something you want or don't want are artificial means of nutrition and artificial means of hydration, food and water, IVs and feeding tubes. So a lot of the state's living wills say, yeah, when I'm a vegetable with no chance of recovery, remove the life support machines, and then you initial one of the two. I direct that the machines be withheld, but keep me on food and water, or I direct that all the machines, including artificial means of nutrition and hydration, be withheld. So some people have a personal preference. I think the mindset of most, although just because most do it this way doesn't mean it's right. A lot of people out there say, when I'm gone, I'm gone. No reason for me to be kept on feeding tubes and IVs if there is absolutely no chance of recovery. So just take me off of everything. Other people say, no, my decision would be to keep the nutrition and hydration intact, but take me off the machine. So sometimes there's decisions to be made on nutrition and hydration. Those are the popular ones. And I've seen some states where they also have elections that a person can make in their living will about not only nutrition and hydration, but also cardiac resuscitation, mechanical respiration, antibiotics. So know that your state may offer, various degrees of care that you can elect to receive or not receive. I'll also say it's worth mentioning, while your wills, trusts, powers of attorney, not in every state, but in many states, and even if it's not required, it's good practice that all of those other estate legal documents be signed in the presence of a notary and two witnesses. That's common. Although that is not common in the area of living wills. Legislatures around the country wanted to be able to enable people to sign living wills. There's typically a requirement that it be witnessed by two people, but not notarized. That makes it easier for people to make their living wills valid. They only have to get two witnesses. Now, I will say, in most states, a relative or someone who might be entitled to inherit from you can't be a witness to a living will. That makes sense. So again, no notary requirement, but be aware of who can and can't be a witness to make a living will valid. I know also in some states, You can make an election. North Carolina is one of them in their state's form, where you can, if you want to, you can state your wishes in your living will, or state your wishes. And then if you want to, you can initial that your healthcare agent that you named can override that advance directive for a natural death decision. So again, just know that regardless of what state you're in, you can maneuver these things to where it's your decision, it's etched in stone, or here's my decision, but I want this person ultimately to have the final say so. All right, some common questions we get with living wills are, because you really need to understand it. Some people, depending on your state form and what your state allows you to do, but I genuinely believe that some people should not have a living will. So, particularly, people need to realize that many of the states have living wills, and if you just sign it as is, you're taking your family out of the equation. And it's when those two doctors certify that you're in that profound comatose state, no reasonable chance of recovery, and all the other conditions are met, then it's time to withhold or withdraw life support machines, no matter what your family say. Some people tell me, Paul, I don't want to put it in the doctor's hands. I don't want I don't want two doctors who, when they say, pull the plug, they have all the say so. Some people say, I want my family. I kind of trust my family to make the right decision more so than I trust the healthcare provider to make that decision. Whether that's right or wrong, that's not what we're talking about here. But many people genuinely, they're kind of afraid to put it in the doctor's hands, and they're more comfortable putting it in the family member's hands. And so when that's the case, maybe you either shouldn't have a living will, or you should have a living will that has the specific directive in place so that the family member that you trust will have the authority and will have the final say so. All right. I get this question. If there's one question that I get about living wills more than other, it's Paul, can I put a time limit on it? Can I put where I got to be out of it for 2 weeks? And I'm like, it depends on your state and depends on what state law allows. But I think they're afraid that the plug's going to be pulled too early. So again, the living will doesn't take effect until there's no chance of recovery. Can you put that desire to keep you on life support for 2 weeks, 2 months, whatever your desire might be? Suppose you can, but who knows what the future holds, and maybe that's just prolonging the inevitable for another 2 weeks or 2 months. So be careful about putting a time limit on there, because the time limit doesn't start until you're in that profound vegetative state. There's no chance of recovery. It's irreversible. It's terminal. And then for people to have to hang around because you put this time limit in there may not be best for you or for your family. All right. I'll also say, even though living wills, the forms can be modified as long as you still follow your state's living will law. Some states' living will forms, the ones that their legislature create, they give you lines and lines of, hey, feel free to write in any special instructions you'd like to write in. So there's your place. If you want this or don't want that, or want to put this condition on it, there's your place to put in those specific instructions. But know that those instructions have to comply with your state's living will law. But some states enable you to write in some special instructions if you want to. All right. So kind of wrapping it up here real quick, the short one this evening is, this is a significant decision that you make. It's kind of always an afterthought when it's done in the overall estate planning process. You do have the right to make that decision if you want to, or by either documenting it correctly in your living will, you can designate someone else to make that decision, or by not having a living will, but having that healthcare power of attorney or advanced healthcare directive or healthcare proxy who would make that decision in the absence of your living will. Um, that all needs to be considered when you make these important estate planning decisions, and know that you can stipulate the desire for certain treatment decisions by doing that initial or check off on the nutrition, hydration, and other options that your state may provide for you in your state's living will law. And also realize that by signing the living will, you may be overriding what your family would want down the road, but maybe that's the way you want it to be because you want to relieve them from that burden and want to take them out of that equation. So with that in mind, there's your basics on the living will slash withhold or withdrawal life support system slash pull the plug decision that so many people refer to it as. I want to thank several of you, Larry, as always, for participating on a short one here tonight. Randy, thank you. Nelbo, probate lawyer, wants to charge, blah, blah, blah. Does that sound fair for a probate case? Depends on the probate case. So, I'm not one to say, but what you're seeing there, $450 an hour, that doesn't really tell you anything because you don't know if it's going to be 4 hours or 400 hours. So tough one there. And I'd probably want to know a little more from the lawyer before I, sign that retainer agreement. Got a question concerning some of the living trusts, Eric. So anyway, we'll be on for the next 4 nights. Feel free to chime in. The next 3 will be more in length, but I did want to have one on this important living will topic. Thank you all for coming. We'll see you next time.